Okay, let's get into it. We're doing a deep dive today on a huge question for California homeowners.
A really critical one.
How do you pass on your home, your biggest asset, without putting your family through the nightmare of probate court?
Exactly. That's the mission. You want to avoid the cost, the time, the stress.
Mhm.
But how you do it? Well, that choice is everything.
And the sources you've brought in lay out two very different paths. First, you've got the simple, cheap option, the revocable transfer on death deed, the TOD
A quick
deeds.
fix.
And on the other side, you have the big, comprehensive solution, the Revocable Living Trust, or RLT.
Which is, a much bigger planning vehicle. It's designed to hold everything, your house, your bank accounts, all of it, and manage things while you're alive and after you're gone.
Whereas the TOD deed is, what, just for the house.
That's it. It's laser focused. A simple document that does one thing. It moves a specific piece of property to someone when you die. No probate.
So our mission today is to really unpack that trade-off. We're going to show you where that promised simplicity of the TOD deed can actually be incredibly dangerous.
And why the extra work of setting up a trust might be the only way to really protect your family's future.
I do.
It all comes down to your situation, really.
Okay, so let's start with the appeal, the TOD deed. It looks so easy. So why isn't everyone in California just using one of these?
The appeal is huge. You can't deny it. California authorized it back in 2016, updated it in 2022, and it works just like a pay on death for a bank account.
You just name a beneficiary and boom, they get the house.
You get the house automatically, no court.
And you stay in complete control the whole time. You can sell it, refinance it, tear up the deed a day before you die.
Precisely. The beneficiary has no rights at all while you're alive. And it's cheap. A few $100, maybe less if you do it yourself. That's the lure.
But there are limits. You can't just use it for any property, right?
No, the scope is very narrow. It's for residential properties. A house, a condo, up to 4 units. Or a small farm with a house on it.
So no commercial buildings, no vacant land.
Off the table completely. That's the first filter.
You mentioned those 2022 updates were to fight fraud, which tells me the paperwork isn't as simple as it sounds.
And that's the tightrope walk.
Yeah?
You have to use the official state form. You have to sign it. But here are the big hurdles.
Okay.
You need 2 adult witnesses.
2.
And they have to be there at the same time you sign. And this is critical. They cannot be the person you're giving the house to.
Ah, so you can't have your son witness the deed that gives him the house.
Absolutely not. And on top of that, it has to be notarized.
That all sounds manageable, but I hear there's one deadline that trips people up constantly.
This is the one. After you do all that perfectly, the witnesses, the notary, you have to get that deed recorded with the county.
Okay.
And you have to do it within 60 days of the notarization.
60 day, not 61. If you miss that deadline or just forget to do it, the deed is void. It's like it never happened. And your house is headed straight for probate.
Wow. What about couples? Most people own a home together. How does it work with, say, joint tenancy?
This is another huge trap. If you own the house as joint tenants with right of survivorship, that right of survivorship wins. Always.
Reigning.
Meaning if you die first, your co-owner, your spouse, usually gets the whole house automatically. The TOD deed you sign giving it to your kids is just ignored. It's void.
So even if you nail the paperwork, the real problems, the hidden dangers, they come later.
That's where we get into the real meat of the issue. This is where simplicity fails. There are 3 ticking time bombs in every TOD deed.
Let's start with the one that can affect you while you're still alive,
Yeah.
the incapacity trap.
Right. A TOD deed is a death document. It does nothing until you die. So if you have a stroke, if you get
The
dementia,
house is still in your name. Exactly. And no one has the legal authority to manage it. Your kid can't pay the mortgage from your account. They can't talk to the insurance company. They can't hire a plumber.
and the result of that is,
The result is your family has to go to court anyway. They have to file for a conservatorship, which is expensive, public, and takes months. It's the very thing you were trying to avoid.
okay, now for the one that I think will shock a lot of people, the idea that your beneficiary gets stuck with your debts.
This is a huge one. It is not a clean gift.
So if I leave my daughter my house with a TOD deed and I have, say, $50,000 in credit card debt,
That debt can follow the house. Your daughter, by accepting the property, could become personally liable for your unsecured debts up to the value of the home.
so creditors could come after her.
They absolutely could. You've basically turned a probate avoidance tool into a debt shifting tool right onto your kids. A trust can protect against that. A TOD deed invites it.
But the single biggest trap, the one that completely undermines the whole point of a quick transfer, is this 3-year marketability problem.
This is the deal breaker for most people once they understand it. The whole point is to give your heir quick access to the asset. Correct.
To sell it if they need to, or get a loan against it.
Well, California law allows anyone to legally challenge the validity of that TOD deed for up to 3 years after you die.
3 years. And why does that matter?
Because of title insurance.
Okay.
A title insurance company will not issue a policy on a property when there's a 3-year window for someone to sue and claim the transfer was invalid. No title insurance means no sale, no refinance.
So my daughter gets the house in her name,
Yeah.
but she can't touch the equity.
For 3 years, that house is effectively frozen. It's an illiquid asset. So the TOD deed avoids probate, sure, but it replaces it with 3 years of purgatory.
Which is where the Revocable Living Trust comes in, because it's designed to solve all of these problems.
Every single one. It's not just about avoiding probate. It's about actual stewardship.
Let's go back to incapacity. How does a trust solve that problem instantly?
Through the successor trustee. In your trust document, you name someone, a spouse, a child, to take over if you become incapacitated.
It's automatic.
All it takes is a doctor's letter. That person can then immediately step in and manage everything in the trust. Pay the bills, talk to the bank. No court, no delay, no conservatorship.
And the scope is so much bigger. It's not just the house.
Right. The trust holds all of it. Your home, your bank accounts, your investments. If you own property in another state, it avoids probate there too. And it's all private.
Right.
Probate records are public. Trust administration is not.
And you get to be the architect. We said the TOD deed is pretty much equal shares or nothing, but with a trust.
You can do anything. Unequal shares, you can have the inheritance paid out in stages, say at age 25 and 30. You can set up special protections for a child with special needs. You're in complete control of the legacy.
Let's talk about protecting the heirs from themselves. The spendthrift clause. That sounds powerful.
It's one of the most powerful tools in estate planning.
So what is it? A protective bubble?
That's a great way to put it. If the assets stay in the trust for your beneficiary, their creditors can't get to it.
So if your son gets a great inheritance from you, but then gets into a bad business deal or a messy divorce?
The money in the trust is generally shielded. His creditors, his ex-spouse, they can't touch it. It's legally owned by the trust, not by him. A TOD deed gives the asset outright, completely exposed.
Okay, the RLT sounds like the clear winner, but it has to have a weakness. What's the #1 way a trust fails?
It's brutally simple, and it happens all the time. People fail to fund it.
Funding it. What does that mean?
It means you went to all the trouble to create this incredible legal document.
Yeah.
But you never actually put anything in it.
You bought a safe, but left the jewelry on the counter.
Perfect analogy. You have to formally retitle your assets. You have to sign a new deed moving your house from your name into the name of your trust, if you don't.
It's just expensive paper.
And that unfunded house is going to probate court. You've spent all the money and effort, and your family still ends up in the exact place you tried to avoid.
Okay, let's talk taxes. Specifically, California's Prop 19, which really changed the game for passing on property taxes. Does a TLC deed or a trust give you an advantage here?
This is a key point. Neither one gives you an advantage. The tools themselves are neutral. Creating a TOD deed or funding your trust does not trigger a property tax reassessment.
So the tax issue isn't the tool, it's what the heir does after you die.
Exactly. Under Prop 19, to keep your low property tax base, the child who inherits has to move in and make it their primary residence within 1 year. That rule is the same whether they get the house from a trust or a TOD deed.
But it gets really complicated when you have multiple kids, right? One wants the house, two want the cash. A trust has to be able to handle that.
This is where a trust's flexibility is essential, but it's tricky. To keep the tax benefit, the distribution has to be equal.
So the trustee has to, take out a loan against the house?
Yes. The trustee, on behalf of the trust, borrows money and gives the cash to the other siblings.
But the sibling who wants the house can't just buy the others out.
Absolutely not. That's the critical mistake.
Why?
Because if the inheriting child provides the money, the tax assessor sees it as a sibling-to-sibling purchase, not an inheritance.
A purchase.
And that purchase triggers reassessment on the shares that were bought out, potentially costing thousands a year in new property taxes. It's a technical minefield that only a well-drafted trust can navigate.
So when we step back and look at the whole picture for you, the homeowner, what's the choice?
The choice is this. The TOD deed is low cost upfront for a very simple situation, but it's fragile. It leaves you exposed to incapacity, and it burdens your heir with debt risk and that awful 3-year freeze on the property.
While the RLT, the trust, costs more and takes more work to set up and fund.
Right. But that work buys you total control. It solves incapacity, it offers incredible flexibility, and, maybe most importantly, it provides that protective bubble for your heir's inheritance.
And when you look at California probate fees, which can easily be tens of thousands of dollars on an average home,
The trust is almost always the smarter investment in the long run. It's about comprehensive protection, not just probate avoidance.
so the goal isn't just to transfer an asset, it's about being a good steward of that asset for the next generation. We have to leave you with this final thought.
Ask yourself this question.
Knowing that a simple paperwork mistake could make your entire plan worthless, or that a hidden rule could stop your child from selling your house for 3 years. Are you really prioritizing convenience, or are you prioritizing lasting security and true peace of mind?